Hello, my name is Alexander, and today we are going to talk about international law. But before we do that, let's talk about just law. What concepts are usually associated with any justice system? You are probably thinking about words like property, territory, title, judge, jury, enforcement, and that's right. These work for most justice systems, but when it comes to international law, things get a little weird, and we'll see why. International law works upon two principles. A principle of autonomy, which is strongly related to the term sovereignty. That means that states hold a supreme and exclusive authority over their territory. No sovereign state can tell another what to do or how to behave regarding an internal matter. A sovereign state is not a colony that has to stick to the will of a government that is somewhere else. The second principle is pacta sunt servanda. This is a Latin locution meaning agreements need to be kept. So basically, if there's an agreement between two states, they should comply with it. However, things start to get a little bit contradictory here. States are sovereign and hold the supreme and exclusive right to rule over the territories. There is no world government above them. States are the masters of international law. So even if there's a principle that agreements should be kept, who's going to make sure that states actually keep those agreements? Who can enforce those agreements if sovereignty protects states from being obliged by other states to do or not to do something? So by this point, probably you have already noticed that there are some entities from traditional law that international law is missing. Who's the judge if there is no world government above states? Who's the jury? What is the source of international law? States have a constitution, but there's no world constitution to follow an international law. And finally, who's the police that enforces whatever international law dictates? International law can be applied to sovereign states that have consented to. So basically, states under an international agreement can just decide not to comply with it anymore, and there's very little other states can do about it because of a principle of autonomy, sovereignty. All these gaps in the concept of international law, when compared to traditional law, make some people question whether international law is actually law. And the main problem with this conception of international law is that it did not prevent a world war. Then a more realistic view of international law was adopted, one based on interests and power. Today, there are countless treaties and conventions among states regarding widely known issues, such as the protection of human rights, humanitarian interventions, the fight against terrorism, border control, diplomatic and consular relations, flight navigation and routes, and many more. Basically, every time you travel, send an email, or even update your social media profiles, a lot of domestic, regional, and international norms are involved. Regarding this approach to international law based on interests and power, there are divided opinions. Some think states have largely lost their status as sole sovereigns, while others continue to question the real effectiveness and relevance of international norms to shape the behavior of states. And how does it work? How does international law work? Well, international lawyers learn different techniques to determine which legal norms exist and are applicable to a certain case. One example of these techniques is interpretation, which is basically arguing for how the words of a legal norm should be understood. Another example is balancing of conflicting rights, which means arguing on how different rights should be prioritized. For example, imagine a patient with a very contagious, hazardous disease. This person has a right to be free and go home, but the authorities could decide to keep this person in quarantine because the safety of the population should be prioritized. These techniques are mainly subjective, but an approximation to objectivity can be achieved through recognized modes of argumentation and processes of conflict resolution. And what's the source of international law? We mentioned that there's no such thing as a world constitution. So what texts do international lawyers and courts refer to when arguing a case? Well, sources of international law are international treaties, customary law, which is basically what has always been done and accepted by law within a sociocultural context. A rule may not be binding on states that have persistently and traditionally objected to it. So this greatly depends on culture and ideology. Other sources of international law are past or historical judicial decisions and scholarly writings. Later in this video, we are going to talk about an example of a specific case international lawyers may face. But for now, let's introduce a couple more concepts in international law: public international law and private international law. Public international law deals with relations involving states, intergovernmental organizations, NGOs, and private companies. Whereas private international law concerns how to deal with conflicts that may arise in situations where domestic laws of different states may apply. For instance, e-commerce, marriages, or liabilities. Another interesting contrast in international law is that of the law of peace versus the law of war, also known as humanitarian law. The law of peace regulates peaceful relations, which include international treaty law, the law of diplomatic and consular relations, international organization law, the law of state responsibility, the law of the sea, the environment, outer space, and international economic law. The law of war regulates the legal use of force during armed conflicts. Note that the killing of human beings is not prohibited, but it does attempt to protect certain categories of persons, such as the sick and the wounded, prisoners of war, and civilians. It also, through specific treaties, prohibits the use of certain types of weapons, such as chemical weapons, biological weapons, mines, and cluster munitions. However, the distinction between the law of peace and the law of war is now blurred. Because if we are trying to promote human rights that are universal, then that means that they also apply to combatants. In my opinion, a soldier has the right to life. In other words, the right not to be legally killed. So, should the law of war continue overriding human rights? That's a complex issue. Now let's talk about a specific case of international norms: the international prohibition of torture. States are subjects of privileges granted by international law, like recognition of sovereign status, immunities, jurisdiction, or memberships in international organizations. But that makes them also bearers of obligations. Those obligations, however, come from voluntary contracts, always respecting the principle of non-intervention, sovereignty. And an interesting remark is that states are subjects of international law, not individuals. If a state tortures a citizen of another state, the former could complain to the latter, but there's very little individuals could do under international law. It would be even worse if a state were torturing its own citizens, as it would be considered an internal matter in which other states could not intervene. Imagine this scenario. A state, let's call it Goatland. So, Goatland has signed and ratified the International Covenant on Civil and Political Rights, which includes a prohibition of torture. Now, imagine Goatland is fighting terrorism and takes suspect terrorist to a prison in a country that is not signatory of the aforementioned convention. In these prisons, the suspects go through so-called enhanced interrogation, which is basically torture. An international lawyer who is assigned to this case could argue that the torture happened outside Gotland's territory, in a country that is not part of the treaty, so it's not obliged to comply with it. However, another international lawyer could argue a case for extraterritorial application of the treaty, as the acts of torture on foreign soil were effectively controlled by a state that is a member to the treaty. Also, if a vast majority of states has ratified the treaties, the international lawyer could argue that a customary rule has been formed. Or if a previous resolution on a similar case dictated a penalization on the country that ordered or controlled the acts of torture, that could also be another argument the international lawyer could use. The international lawyer could also argue that considering the vicious nature of the acts, territorial limitations and other exceptions should be overridden. If you convince the Assembly or the International Court, it may definitely result in sanctions to Gotland. Let's talk about a Netflix series like Casa de Papel, in which basically this scenario happens. Spanish police take Rio to another country to be tortured. They are so worried that an international organization interviewed Rio, because if Spain were found guilty of torture, that could definitely end up in many sanctions, which could potentially impact Spain's economy and their reputation worldwide. The officials who ordered the torture could be prosecuted by the Spanish justice system itself, because in order to be signatory of certain treaties, sometimes a requirement is, for instance, to include a prohibition of torture in your own domestic law. What a state official wants to go to jail, and if that happened, it would also have political consequences to the party in power. Many Spanish citizens probably would not vote for that party again in the next elections. So can you see how the current approach to international law is definitely powerful and cannot be easily overridden by sovereignty? There are two major historical events that caused and accelerated the development of international law: the end of World War II and the Cold War. After World War II, the United Nations were founded. The founding treaty confirms as guiding principles the sovereign equality of the member states, the peaceful settlement of disputes, the prohibition of the use of force, and the principle of non-intervention. The Security Council is the highest executive organ of the United Nations, and it consists of 10 selected members and 5 permanent members who decide on issues of peace and security through binding resolutions, which may be economic sanctions or even military actions. Today is the year 2021, and Mexico is currently a member of the Security Council, and interestingly, the governmental media apparatus try to present it as some sort of an achievement of the current administration, or as a proof of a better perception of Mexico by the world. But that's inaccurate. Being part of the Security Council is by no means a recognition of anyone's administration by the international community. Most countries get to be part of the Security Council every certain period of time. Mexico was also part of the Security Council in different periods of time in which the opposition was in power in Mexico. You may check the years yourself on the UN website under the Security Council member history section. Now let's talk about how the resolutions are processed by the Security Council. In order for a resolution to be approved, it must get 9 positive votes, and none of the 5 members with the right to veto must issue a negative vote. The right to veto is a special status enabling the 5 permanent members to ban any resolution even if it gets the required 9 votes. Those members with the right to veto are China, Russia, France, the United Kingdom, and the United States. The right to veto was a necessary concession to ensure the participation of the most powerful states in a world organization. Finally, let's talk about how international law becomes law. We have seen how much power and relevance international law may have with the hypothetical case of Spain in La Casa de Papel. But the idea of a norm prohibiting a torture started long before it was actually codified in a treaty. These norms begin with social activism, sometimes by very small groups of individuals, the so-called norm entrepreneurs. Then the idea starts spreading using different tools such as lobbying groups, NGOs, campaigning, empathy appeal, persuasion, shaming, claiming, declaring, you name it. Let's call them sales tools, because at the end of the day, what you are trying to do is to convince people of something. So the idea spreads and influences more and more people until it persuades governments to embrace it. Then the formal adoption of a norm by a state may inspire other states to follow the same path until the norm acquires a taken for granted status. And finally, it's codified in a formal treaty with signatory states, binding compromise and even enforcement in the shape of a series of possible sanctions in case the norm is violated. And those sanctions are also formally codified in the treaty. So now individuals can benefit from it. Remember that earlier we mentioned that international law is rather for states than for individuals. But when a norm gets to this point, individuals can also benefit from it. Think about it. When you travel to whatever country, you are protected from violations to your human rights. Basically, wherever you go, you are protected against torture by an international treaty that forces signatory states to prohibit torture within their territory. So, an international norm has permeated in domestic law systems to reach the individual. Of course, this is still imperfect. It is not a perfect guarantor that your human rights will be respected wherever you go. I mean, unfortunately, torture and other violations of human rights still happen today. But it is, in my opinion, much progress, not only for international law, but for humankind.